Alberto made the rights above that. What the people in New Jersey need to realize is that D.C. and Chicago fell. And he's right. Nobody thought D.C. would fall. Nobody thought Chicago would fall and McDonald. Almeida goes on, so can New Jersey as long as you fight for it. And really that's the Cheeseman case, okay? Since 1971, no one has won a 2C58-4 permit case. And when I say that, not an individual case. Obviously, Almeida won his case individually, but no one has changed the law. When they get close to losing the law, they start to issue a permit. The Cheeseman case is different from Rogers and Drake, okay? This is what you need to understand about Cheeseman. Cheeseman does not go after the statute. Cheeseman doesn't go after 2C58-4. That's what Rogers is doing. This is different. We're fighting the state here on multiple fronts. Cheeseman is acquiescing that the statute is valid. No judge wants to overturn the statute. And I think that's one of the problems that we've had over the last 40 or 50 years is that nobody ever wants to hold a statute unconstitutional. And the judges really don't know what the law is or where it came from. So they're just working off of precedent. We leave the statute alone. And the argument, which is the third argument in Cheeseman, is that justifiable need is synonymous with Heller's lawful purpose. And we know from Heller that the core lawful purpose of the Second Amendment is self-defense. So if the Cheeseman case wins, all you have to do, if you have a 2C58-3 permit, all you have to do to get a 2C58-4 is qualify for the shooting test, and on your permit application where it says need, write self-defense, okay? If you go to Black's Law Dictionary, this is Black's Law Dictionary, and you search need, justifiable, lawful, and purpose. Justifiable need is the exact same definition as lawful purpose, okay? Here's the second part of the Cheeseman case. Heller has taken case-by-case determinations off the table. Page 2821. I'm going to read it to you because you need to understand this clearly, exactly what Heller 2821 says. Okay, so I'm going to read this because I don't have it perfect, just coming out of my mouth. We know of no other enumerated constitutional right whose core protection has been subjugated to a freestanding interest-balancing approach. The very enumeration of the right takes out of the hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon. Understand, in the paper, really worth insisting upon was emphasized. A constitutional guarantee subject to future judges' assessments of its usefulness is no guarantee at all. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them. Whether or not future legislatures, that's you, Loretta, or yes, even future judges think that the scope is too broad. That's important, okay? A constitutional guarantee subject to the future judge's assessments of its usefulness. That's what the Siccardi rule is. It was a test case. They brought in the police chiefs from Cranford, Westfield, Shrewsbury, Plainfield, and there was one other police chief there. And all of them said that having a gun during the commission of crime was worthless because the crime happened very suddenly and no one could use their gun to defend themselves. And if they did try to use their gun, the criminal would steal their gun and usually turn the gun back on them. That was the testimony. It came right out of Zimring's final report, 1968-69 law review. Right off the pages of the law review. So basically what the cop said is, we carry guns, but we know better than everyone else. We know how to handle them, but you people can't have them, okay? Now, the first part of the Cheeseman case is important. First part of the Cheeseman case is that New Jersey actually prides itself that they determine 2C58-4 permits on a case-by-case basis. New Jersey says the whole reason its permitting scheme is constitutional is exactly because they determine permits on a case-by-case basis. Okay, so I'm going to read you the most current appeals court case at the time. The Cheeseman case was mostly finalized. Okay, Cheeseman Case was actually written in the theory of the Cheeseman Case was written in 2011, 2010, just after McDonald, but it was a work in progress until it got to Cheeseman. But the most current case in the New Jersey Appeals Court was Wheeler, and here's what Wheeler says. In the context of the grid of our firearms laws, the justifiable need component of the carry permit law is best understood as accommodating on a case-by-case basis those who have a reason, one based on more than a generalized concern about the prevalence of crime, to anticipate a violent attack in a public place warranting lawful defensive use of a handgun. That's on page 739. Okay? So the New Jersey Appeals Court has put on paper that it decides 2C58-4 permits on a case-by-case basis. We know since 2008, Heller has taken those off the table. Here's Wheeler again on page 759. The justifiable need requirement serves the same purpose as the employment-based exceptions, but does so on a case-by-case rather than categorical basis. Basically what they just said there was there is no right to have a 2C58-4 permit. It's an exemption that goes into the 2C39-6 or the 2C39-5E exemptions, like you work in a rail yard or you're a dog catcher or a fire arson inspector or all those other exemptions that are in there. Okay, let's fast forward to 2003. This is Berinsky. We hold that each application must be dealt with on its own merits on a case-by-case basis. Here's Stratton in 2010. In considering whether an applicant has demonstrated a justifiable need to carry a handgun, the court must evaluate each application on a case-by-case basis. One of the reasons that we go after the code and the Sicardi rule to get them severed from the statute, and we don't go after the statute, is because Drake was lost. Okay? And I'm not so sure Drake being lost was Jensen's fault. I just don't think it was time. I don't think the Heller Scholarship was up to date when Jensen did Drake. I don't think that these judges actually knew what it meant. I think everybody cherry-picked on long-standing and presumptively lawful. I think everybody cherry-picked on that in the home, and nobody actually knew what Heller meant. The scholarship has become more advanced now, where I think if you got the right court, you could beat the statute, but we don't have to beat the statute here because judges will, to save the statute, sever the code in the Sicardi rule. But this is how bad federal court is, okay? Because this is the decision in Drake at 439. New Jersey has decided that this somewhat heightened risk to the public may be outweighed by a potential safety benefit to an individual with a justifiable need to carry a handgun. Furthermore, New Jersey has decided that it can best determine when the individual benefit outweighs the increased risk to the community through careful case-by-case scrutiny of each application by the police at a court. So, Cheeseman has three parts to it. Justifiable need is lawful. That's the only thing that saves is a lawful purpose. That saves the statute. It allows the judge now to cut the code NJAC 1354 2.4D-1, okay, which is the Sicardi rule, which is you need to survive previous attacks or have documented threats. Okay, you need a special need above anybody else's need to get a carry permit. What Cheeseman's doing is it's forcing New Jersey either to say Cheeseman's right, we can't decide permits on a case-by-case basis anymore, or write on paper that we are going to openly defy the Supreme Court of the United States in Heller and say, no, we're allowed to still decide permits on a case-by-case basis. Because if they do that, and you have that on paper, and you turn that into a federal court, and now you do exactly what we just did here, you show the federal court Heller threw out case-by-case determinations for Second Amendment permit applications. New Jersey says it can still utilize case-by-case determinations for permit 2C58-4 permit applications. Now, right away, the federal court knows. New Jersey's in open defiance to what Heller said on page 2821. Also on McDonald 3050. That's the case. Don't believe these people that there's only one case. Everybody should be applying for carry permits. Everybody should be using this argument. Everyone, we should have 100, 200, 300 people down at the Superior Court on any given day. We should have 100, 200 cases going in an appeals court every day. This is a scam that's been perpetrated by New Jersey since 1970. The Sicardi rule was made up by the investigation unit of the state police. They decided they wanted to make need more strict than Sills called for in the 1966 statute. Obviously, when it got to the Supreme Court of New Jersey, the Supreme Court judges and the prosecutors and the Attorney General realized it never passed the Administrative Procedures Act, so they made up this nonsense that it was a assignment judge's rule. Well, it's not a rule. These are the court rules, 2018 edition, 3,000 pages. The Sicardi rule is not in here. It does not exist. We need to attack New Jersey on this. We need to be relentless. We need to get them on paper defying Heller.